Hello, this is Rob Lambert with AssetProtectionTraining.com. Today I'm going to do an overview of the entire asset protection universe. I'm going to move quickly, but I'm going to try to cover nearly everything. I'm going to start with my favorite, offshore. I'm going to talk about the key rules. Pay attention, look at those, they're free, and they will save you a lot of time and trouble, no matter what you do with your life. Then I'm going to talk about asset protection trusts, how they work, how they're normally structured, how do you combine them with family limited partnerships and other entities. I'm going to show you a diagram that will help you. And then I'm going to talk about some of the key issues to keep in your head when you go shopping for asset protection so that you don't get in the hands of a scammer. Pretty simple rules, but they will help you. Then I'm going to move on to domestic asset protection. I'm going to talk about domestic asset protection trusts. I'm going to talk about techniques to protect your real estate and keep your domestic situs assets safe and protected. I'm going to talk about pension funds. I'm going to talk about ERISA, IRAs, and similar entities. How safe are they? Then I'm going to talk about corporations, LLCs, partnerships, and other statutorily provided tools and techniques that vary state by state, but are valuable and things that you should always consider no matter how complicated your asset protection needs are. Never forget the simple domestic steps. I want to start with the key rules of asset protection. These are rules that are fundamental, that are basic. They're inalienable, like rights of liberty. What you don't own, the first rule is what you don't own cannot be taken from you. Think about it. What you don't own cannot be taken from you. That's like Newton and his apple falling. Nobody thought too much about gravity till he started writing about it. Nobody articulated that rule till about 15 years ago. I decided to write it, but we all know it. What you don't own cannot be taken from you. For example, you have a new baby. The day the baby's born, you give the baby $10,000 in a trust for education. You've made a gift. Provided that gift is not a fraud on your current creditors, nobody can take that away. 10 years from now, when somebody decides to sue you and they can't collect because you've done good asset protection, are they going to be able to go after your 10-year-old and take that college fund, which is growing to $20,000 away? No. Why? Because it's not yours. And your act of transferring it to your kid was not a fraudulent conveyance. Well, a trust is the same thing as a kid. You'll soon find all that out. So the first rule is what you don't own cannot be taken from you. Second rule, just as obvious, no country in the world automatically enforces U.S. judgments. Say it again. No country in the world automatically enforces U.S. judgments. Every single country out there forces anybody who wants to take your money away to re-sue you and litigate in a hostile environment if they want to get to your money. And the good parts about it is most of the rest of the world have serious impediments to people being able to win those suits. Most of the world, 99% of the rest of the world, thinks contingent fee litigation is immoral and unethical, as I do. I believe it's a complete conflict of interest. We have 130,000 lawyers graduating each year, most of them with nothing to do. Well, any one of them can file a lawsuit for $200 or $300, sue you for $10 or $20 or $30 million, ruin your health, ruin your sleep, ruin your capacity to move forward in some cases, all because they have the power to, and they have nothing else to do. So we get to choose, by applying those first two rules, we get to choose our battleground. Remember, first rule is what you don't own cannot be taken from you. Second rule, no country in the world automatically enforces U.S. judgments. It'll start to make sense to you in a few minutes, but just file those away and tattoo them into your brain. That's a good start. Third rule, trust nobody. Trust nobody. Always assume when you do asset protection that your trustee and your advisors are not on your side. Why should you assume it? Well, because they normally aren't. Even lawyers, although they try to clothe themselves in the sacred shrouds of decency and integrity, they're mostly just callous, self-indulgent people who want to make money for themselves, just like most businessmen. The honor in the law is pretty well gone. So don't count on anybody looking out for you other than yourself. Take control, and that's what I'm going to give you the tools to do. You're going to have the tools to control the risk you take and understand the advice you're paying for, to make sure that you're getting good advice. Now, trust nobody. That'll make sense to you in a little while, particularly if you start doing a serious asset protection strategy. All the time you'll be beset by people saying, trust me with your money, put it in here, put it in this bank account, move it here. You never need to lose control of your money. Never ever lose control of your money, ever. Very, very important. And this is a good one. If somebody promises you that asset protection will save you any taxes, run. Because it doesn't. Asset protection is compatible with all tax planning, including insurance planning, and that can save you taxes and be part of an asset protection plan. But except for that unique niche, asset protection does not save you taxes. Pay your taxes. The United States, although we all hate to pay them, has some of the lowest tax rates of any civilized country in the world. We're unfortunately also one of the only countries that taxes its citizens on their worldwide income from whatever source derived. That's an exact quote from the code. You're taxed on your, quote, worldwide income from whatever source derived. Well, you know what? That's a bad deal. And I do have people expatriating, but that's not for most people. That's probably not for you. Pay your taxes and be happy. You're in one of the lowest tax rate jurisdictions in the whole world. I'm going to talk a little bit about bank accounts. Darn near impossible to get nowadays. Fortunately, people who take this course and follow the suggestions I give them will be able to get, or should be able to get, bank accounts. But since the Patriot Act, since the rise of terrorism in the United States and the rest of the industrialized world's effort to counter terrorism, there's been a real big focus on offshore banking. And the Know Your Customer rules from the Patriot Act and the 7 money laundering statutes that work with the Patriot Act are very strong, and they make it so that most big offshore banks don't even want to do business with a normal human being. I'll show you how to get around that and find banks, but always stay with solid banks. Never go to less than a Fortune 50 bank. You need somebody stronger than Bank of America, stronger than Chase, stronger than Wells Fargo, and they really exist. And don't take some boutique bank. Don't trust them. They will steal your money. I can almost guarantee you'll have problems. Stay away from the boutiques. You're going to be beset by people making promises to you. How to spot the creeps out there? Well, again, if they ask you to trust them, run. If they promise to save you taxes, run. If they tell you that your bank account is secret, and in fact, a lot of them will tell you you don't even have to report it, just get a debit card and you'll be safe and sound, run. You'll be rooming with Bubba. You do not want to commit tax fraud. Every time you do asset protection, it should be completely above board. It should never rely upon stealth. You should be able to hold your head up high, look a judge, look a creditor in the eye, and say, yes, here's what I did. You're not going to volunteer anything, because stealth does help, but you should never depend upon stealth. Stay away from that. Stay away from Nevada corporations. Unless you live in Nevada, you shouldn't do it. Nevada corporations are, in most cases, worthless scams. Absolutely worthless scams. There's no such thing as bearer shares in Nevada. There's no such thing. It was all started by Bill Reed and his asset protection group. He's in jail, or at least went to jail. I hope he's still in jail. Complete scammer. Stay away. Stay away. If you're going to do domestic entities, we'll talk about that later, but they almost always are problematic. Don't rely upon that. Another thing you should always try to avoid is the fraudulent conveyance issue, but don't be paralyzed by it. Fraudulent conveyancing is not a crime. What it is when you transfer money into a protected environment and don't retain sufficient assets to meet your reasonably anticipated debts. That's pretty much it in a nutshell. Always be careful when you're doing your planning, but don't be paralyzed. If somebody has sued you and you have a decent defense, then don't just lock up and say, well, I guess I just can't do anything. I'll have to leave my $2 million sitting in Chase because I don't want to engage in a fraudulent conveyance. Look, normally with a little analysis, you can come up with a decent guess as to what you owe the people suing you if you've been sued, and then protect the rest of it. And, have a good business purpose, and believe me, it's a whole lot better than being vulnerable. And this gives you the power to take control of your life. You never have to be vulnerable. That's what I like about asset protection. It's like delivering healthy babies. What is a trust? What is a trust? A trust is nothing more than a little teeny tiny simple. I mean, it can have 200 pages long, but it's nothing more than a contract between somebody who puts something into a trust, that's called a settlor, or a trust maker, or a grantor, and a trustee. That's the human or the company that's licensed to or authorized to hold the stuff, whatever you put into trust. The contract is between the settlor and a trustee or the trust company. And the trust company agrees to hold whatever the settlor gave it or gave him. For instance, if you put $100,000 into a trust and say you went to your neighbor and said, well, you hold this $100,000 for my kid until he graduates from college, then give it to them. Well, give it to him. You've done a trust. It doesn't even have to be written, although they all should be. Oral trusts are ridiculous. That is a trust. A trust requires a settlor, a trust company, and a beneficiary. In that case, it was your kid who was going to school, got the money when they graduated. Trust can be much more complicated, but if you do trusts correctly in the asset protection world, the trust is that brand new baby I discussed earlier. The trust is a separate human almost being. A trust that's properly done has all the powers of a human being to do anything that a human being can. It is treated as if it were a living, breathing person. And therefore, transferring assets to a trust is a great way to trigger the first rule of asset protection. What you don't own cannot be taken from you. When you transferred it to the trust, you no longer own it. It's not yours. It's not available to your creditors. And the second rule just puts a little bit of icing on that cake, because if you're worried about U.S. courts following the law, and believe me, they don't follow the law, they redistribute wealth. Courts are not fair. They will never be fair in this country as long as we don't have the rule of law. We have a rule of judges who do what they feel is appropriate in the circumstances, and they can decide against you even though you abided by exactly what the law, the statutes said. So never, ever, ever, ever trust even the judges to do the right thing. An asset protection trust will have some unique provisions. It'll have a Cuba clause. A Cuba clause will allow your trust to migrate from one jurisdiction to another. They used to be automatic. We stopped making them automatic when the tax law changed about 10 years ago. But bottom line is, if your trust is in Belize or the Cook Islands or St. Lucia or any place, and somebody starts to attack your trust in one of those jurisdictions, your trust may migrate. It may migrate to another jurisdiction. That takes about 15 minutes of work on behalf of your advisors, or you, if you know how to do it. It takes your creditor about 6 or 8 months to recover, because they have to go hire a whole new team of lawyers in another country. They have to pay them. If there's conflicts of interest, they'll even have to bring in lawyers from outside the country, usually England, and it just makes it incredibly expensive. They'll have Cuba clauses. They'll have anti-duress clauses. An anti-duress clause is simply a clause that says if a judge orders you to do something under duress, the trustee is not to listen to it. Now, it has to be really carefully written, or you're going to have a lot of angry judges. But we have some pretty good examples of what a duress clause should look like. And look at the real purpose of this. The real purpose is to make your creditors spend $10 to collect 10 cents. They get really tired of that because no lawyer in the entire world litigates on principle. They do it for one thing. That's to make money. And they're not going to do it. They're not going to continue to waste their time. They may be mad at you, but you're going to get to keep your money. I want to talk a little bit about a structure that I sometimes like, and this is all going to make sense to you when I'm finished. I do a lot of asset protection trusts that are combined with family limited partnerships. That means I have the family limited partnership. And by the way, there's no such thing as a family limited partnership. It's just a word that lawyers invented to make partnerships more expensive. A partnership you might charge $2,000 for, they'll charge $4, $5, $10 for. Because what? It's a family limited partnership. It has a few extra pages. It's no different. It's no different. Don't fall for that. But anyway, if you take a partnership and have it owned 99 or even sometimes 100% by the trust, that's a great way to have U.S. situs bank accounts that are protected. I oftentimes do that. I use the partnership to separate ownership, which stays with the limited partner, usually 99%, from control, which stays with my client. My client will usually own very small portion, 1% or less, but have 100% control by virtue of their status of being the general partner. The limited partner trust will have no control. Therefore, the limited partner trust is not liable to be sued, and if it is sued, it's dismissible because the limited partner trust has no capacity to take any action. They can't commit a tort. They can't do anything bad because limited partners, by virtue of the statutes in all the states, have no power at all to make important decisions that expose the partnership to liability. Well, the good part about that structure is it allows the trust, which anything in the trust is off your balance sheet, the trust to have bank accounts in the United States that are still protected. They're still not yours. The statute of limitations has started to run the moment it's funded, even if the money's sitting at Bank of America. I want to talk now about domestic asset protection planning. Domestic trusts. You hear a lot about Alaska trusts, Delaware trusts. 14, 15 places now are touting asset protection, domestic asset protection trusts. Again, it's a bunch of bull. It's a bunch of crap. It does not work. Why? Because the Constitution has the full faith and credit clause. If I get a judgment against you in California and you have a Delaware domestic asset protection trust, do you think a federal court is going to hold Delaware law above the Constitution of the United States? No. And the Constitution says that a judgment in California needs to be given the full faith and credit, needs to be given complete recognition in every other state. Domestic asset protection is a marketing gimmick. The state legislatures are trying. It just doesn't work. It has never been tested. The only time it could possibly even come close to working, say with a Delaware trust, is if you had a plaintiff in Delaware. Everything involved took place only in Delaware. The defendant was only in Delaware. The money was in Delaware. It was only involving Delaware law. There was no involvement from anybody else anywhere. Possibly, then, there'd be no federal issues at all. But all I'd have to do is sue you in another state, and you're out of luck. So stay away from it. It doesn't work. Don't get taken by that. Now let's talk about some of the statutory things, just briefly. You all need to do this. You all need to take care of your families. You all need to homestead your homes. You all need to do it. Some states it's automatic. Some states it's requires some action, some documents to be filed. Not such a big deal to do that. But you need to do it. Make sure you look at pension planning. ERISA plans are safe. They are really safe. As long as they're not overfunded, your ERISA plan will withstand a creditor attack. It's what kept OJ in the pink after he murdered that lady. Or I guess he didn't murder that lady. At least justice is done. He's finally in jail. But ERISA plans work. Do IRAs work? That's something you can't ever be sure about. There are tricks to turn IRAs into ERISAs. There are tricks to get money out of IRAs and protect it. Asset Protection Trust is infinitely better than most IRAs, but IRAs are still pretty darn good. Insurance is great. Insurance, life insurance, is usually asset protected. Spendthrift provisions and trusts. The reason why I'm in business, the reason why people pay me to do asset protection is because of one set of rules. You can't do a self-settled asset protection trust in the United States. If you put together a trust for yourself and try to rely upon a spendthrift clause, it is ineffective. If you put a spendthrift clause in a trust you do for somebody else, like a child, and you say your child's a son, say his name is Bill, you say, here's $100,000 for Bill, and I want Bill's creditors to not be able to get this money as long as it's in the trust. Believe me, that will work. That works. Bill's creditors cannot get to that money, but Bill didn't settle the trust. You did. You can't do it for yourself. That's the only reason I even make a living. Don't forget tenancy by the entirety. 13 states have that. That's a good way to protect your home in many states. In a lot of those states, creditors can't take your assets that are held in tenancy by the entirety away until both the husband and wife is dead. It's kind of a nice thing. Beware of the bankruptcy exemptions. Beware of the insurance exemptions. Beware be aware of plans for, college saving plans for kids that are good. Take advantage of the easy things. Also, always have a decent estate planner. Always have an estate planner and an accountant by your side. But don't take it lightly, and it can save you an awful lot of taxes if you do that correctly. And your asset protection plan should always be integrated with your estate plan. It's very easy to do if you've done it correctly. If you've done an asset protection plan correctly, it is always integrated with your estate plan by some provisions I'll be sharing with you later on in these courses if you take them. Well, that's my overview in a very short few minutes of asset protection. I hope it's been helpful to you. I hope that you enjoyed it. And my goal is to see every single human being in the United States with two nickels to rub together protected. And I want each of you to be safe and sound. This is Rob Lambert, and I do look forward to getting to know a number of you, and I do look forward to helping you protect yourselves. Thank you very much. Bye-bye.